The Home Office has published a 111-page statement of changes to the immigration rules, introducing significant updates across several visa categories. These changes reflect commitments made in the Immigration White Paper and aim to streamline the system while ensuring alignment with economic and policy objectives. The source of this information is the UK government's HC 133350 October 2025 111 pages Statement of Changes to CRIPTAS Immigration Rules. You can check it out on gov.uk. We will of course break down everything to you in this video to the best of your understanding, as we usually always do. But before we begin, we want to beg a small favour from you. Only about 1% of those viewing our videos are subscribed to the channel. Please help us subscribe, as this gives us motivation to continue creating content just like this one. Thanks. Now, let's get straight into the change. Change number 1. Introduction of dependents for stateless people. A partner or child of a stateless person may apply for entry clearance or permission to stay under from the 11th of November 2025, where they formed part of the family unit before a stateless person was granted permission to stay. Those applying as a dependent on this route will need to meet the relevant partner or child requirements. Alternatively, where the partner or child of a stateless person are not themselves stateless and formed part of the family unit after a stateless person was granted permission, they may now apply to come to or stay in the UK under the family provisions. Change number 2, taking effect on the 11th of November, German students under the age of 19 can come to the UK without an advance permission, an ETA or visa when they are travelling as part of a school party of 5 or more. It also allows EU, EEA and Swiss nationals aged 19 and under who are studying at the school to travel on a national identity card rather than passport. Change number 3, changes to English language requirements for economic migration routes. The English language requirement for the skilled worker, high potential individual and scale-up routes is increased from B1 level to B2 level, as defined under the Common European Framework for Reference for Languages, CEFA. The new requirements will apply to those seeking an initial grant of leave in a relevant route, following the implementation of these provisions on the 8th of January 2026. Those who have already obtained a permission where they were required to show a B1 level will continue to be subject to a B1 level requirement where they are seeking an extension on the same route. Change number 4, high potential individual. Targeted and capped expansion of eligibility. How does that work? Well, the government is doubling the number of universities whose graduates can use the route, but also capping the number of places that are available in this route at 8,000 per year. So the cap of 8,000 is not expected to be reached. That begs the question of why have such a cap then? Presumably it is to guard against an unexpected, very large increase in applications. Change number 5. The global talent route is also getting some love, with the gateway list of eligible prizes to be expanded, along with some changes helpful to architects. Architect applicants will be allowed to provide evidence of their achievements as a named member of a group or contributor, as well for their work as an individual, and provide evidence of significantly contributing to being shortlisted or nominated for an international architectural award. Change number 6, duration of stay under the graduate route, reduced to 18 months. The graduate route currently allows eligible graduates who have successfully completed a UK bachelor's degree, master's degree or other relevant qualification to remain in the UK for 2 years, and PhD graduates for 3 years. This is being reduced to 18 months and will apply to applications submitted on or after the 1st of January 2027, with PhD graduates continuing to receive 3 years of leave. Change number 7. Students to transition to the Innovator Founder route. A small tweak, but a welcome one, for those who benefit. With effect from the 25th of November 2025, a student will be permitted to be self-employed, for example to establish a business where they have completed their course and are switching to the Innovator Founder route. This is how it used to work for those switching into the old startup route. The financial requirements for student visas will be increased for the 2025-2026 academic year unsurprisingly. Change number 8, temporary work and seasonal worker visa changes. Seasonal workers will be able to spend no more than 6 months working in the UK during any rolling 10-month period rather than any rolling 12-month period under the previous rules. There's also a 4-month cooling off period before a person who was previously working as a seasonal worker may re-enter in the same category. The new rules apply for applications made on or after the 11th of November 2025. Change number 9. Ukraine Permission Extension Scheme. A slight tweak to allow a child's leave to be aligned with a legal guardian as well as with parents, along with some other changes which sound minor from the explanatory statement but might well need some closer scrutiny. Change number 10. Introduction of a visit visa requirement for nationals of Botswana and recognition of Palestine. Changes to the visa national list with immediate effect at 3 p.m. from 14 October 2025, but with some transitional protections. We've put out a separate short post explaining briefly what that means in practice. Palestine has also been added to the visa national list, with effect from the 11th of November 2025, meaning Palestinians too must apply for a visa before attempting to travel to the UK. Additionally, grounds for refusal were replaced with part suitability. What we used to call general grounds for refusal are being replaced with new, consolidated, universal suitability requirements. The separate Appendix FM suitability rules are being scrapped and rolled into the new general ones. The change takes effect on the 11th of November 2025. In principle, this is probably a helpful change because the negative nature of the refusal grounds made them pretty confusing to explain to new lawyers, which is never a good sign. Applications which looked like they would succeed would actually fail because of a non-cross-referenced override situated elsewhere in the rules and thereby effectively hidden. But this change is going to take us existing lawyers a while to get our heads around, as the old Part 9 goes back to time immemorial, or to be more precise, 1994. I have not had time to review and analyze the new text and compare it to the old version to see if there are any substantive changes. There are also a lot of technical consequential changes because there were a lot of references to the old general grounds and various old suitability requirements as well. Nothing was mentioned about ILR and citizenship in this statement of changes, but earlier Home Secretary Shabana Mahmood announced that ILR will change from 5 to 10 years and gave some criteria for it, but the government will give further details in due course. So for now, those are the most recent changes to immigration rules which the government just published in its latest statement of changes. The full document can be found on the gov.uk website. You can check that yourself. Please, if you found this breakdown helpful, share the video and leave your thoughts in the comment section below. Also, don't forget to subscribe to our channel and ring the notification bell for upcoming updates. Thanks for watching and have a great day.